have two excellent guests with us tonight for HLPA's March meeting, Simon Cox and Bethan Lant. Bethan's going to speak first. Bethan is from Praxis. Praxis is a charity for migrants and refugees, helping migrants at risk and providing immigration and housing advice. Bethan will set out what the reality is like for asylum seekers, if you like, on the front line, and what the obstacles and difficulties are for them, and the advice that and the difficulties in providing them with assistance in the light of the current legal climate. Second up will be Simon Cox. Simon, of course, is well known amongst housing lawyers generally. He specialises in immigration, housing and social welfare. And Simon will follow after Bethan's talk and will talk about some of the legal issues surrounding asylum seekers and housing. So two excellent speakers. We are very fortunate to have them here this evening. And perhaps, Bethan, if I can start with you.
Yes, certainly. Hi, good evening, everyone. I'm sorry if we're the best night out on St. Patrick's Day this year due to lockdown, but maybe you might feel like a drink by the time we finish talking, who knows. Anyway, as Marina says, I'm very much talking from a frontline perspective about some of the challenges of asylum support, and really in some ways from a very non-legal perspective, just talking about what we're seeing on the front line. But in particular, I wanted to talk about one particular situation with respect to asylum seekers in London, which has been developing over the last 6 to 9 months, really, and what's happening there. Now, as Marina said, Praxis is an organisation working with migrants, and we include in that refugees and asylum seekers. We're based in East London, but we work with clients across London, and we do a mix of casework and advice on immigration and destitution rather than strictly straight housing. It's more looking at some of the issues around destitution, particularly around no recourse to public funds, and occasionally around asylum support issues as well. We also do some advocacy and influencing work in areas of particular interest to us, no recourse to public funds again being a big area, and migrant rough sleepers, since we work with a lot of homelessness organisations. So what I am going to talk about this evening is temporary asylum accommodation, not those held in the barracks, because my knowledge of that is probably like yours from the newspapers that I read. But what I'm talking about is these asylum seekers who are being accommodated in London. Now, I should start by saying that although we do work with asylum seekers, they're definitely a small proportion of the people we see on a daily basis. For two reasons, really. One is that we don't do legal aid immigration advice, so we don't get many asylum applications through our door because of that. And also because while asylum seekers might first arrive into London by one of the big airports or be part of a migrant community in London at the point they make their asylum application, once they do claim, if they require asylum support, then most of them are moved to accommodation in the dispersal regions outside London in the southeast. So they're very quickly moved out of London and we don't get to see them. Sometimes in the past, or usually in the past, people were accommodated initially when they claimed asylum in a few big centres or hotels out in West London as part of what's known as Section 98 asylum support. So that's the fairly short-term support that you get before you're dispersed, before you move into Section 95 accommodation. But the idea is that that's quite short-term and that you'll be sent off to dispersal accommodation quite quickly. Hence, we don't see many asylum seekers, or we didn't. I do quite a lot of work with local authorities. We work in partnership around rough sleeping initiatives and things like that, and looking at issues around migrant homelessness. And at the beginning of this year, I was in a meeting with some people from the London Borough of Newham, and they were venting their frustration and talking about a large number of asylum seekers who'd been accommodated in 2 hotels within the borough in initial accommodation, in Section 98 accommodation, and that the borough had received no notification from the Home Office of their intention to place people there, and didn't know they were there until they were notified by some local agencies. I was asked to give some advice and support to a few of the organisations who were helping them. And I had quite a number of interesting conversations with some volunteers from Care for Calais and a couple of local churches who were providing help and support to people. I was a bit perplexed by this particular incident, but I thought it's just an anomaly. It's just a one-off thing that seems to have happened. And then an organisation quite close to me in Tower Hamlets, where Praxis is based, asked, did I know anything about a load of asylum seekers who'd been placed in 2 lots of accommodation close by to Praxis? And because they'd been turning up at local churches saying that they had no food. So I started making some inquiries. And I soon realised that this was the same thing that happened in Newham, which had also happened in Tower Hamlets, that asylum seekers had been placed in the borough with no notification or liaison with the local authority or other local stakeholders, and all the local agencies were scrambling to catch up with what was happening. I brought the matter up at a GLA meeting on refugee and migrant issues that I attend, and an organisation based in North London said, yes, actually, we're seeing the same thing. We've had a couple of hotels near us where people are being accommodated, and I've heard of them in Southwark and Lambeth as well, all with similar lack of notification or information shared with the local authorities. So I kept digging. And very soon, I was quite surprised to find out that suddenly, at this point, as far as we're aware, there are now 34 sites accommodating asylum seekers in what's called initial accommodation across London. The main source of where these hotels are, and that we have 34 of them, has come from Care for Calais, who seems to be the only organisation who's able to collate this organisation, since the Home Office aren't telling anyone anything. So the only bigger picture we get is from Care for Calais. And what we also see in each area is, again, that local authorities and stakeholders are not informed in advance and are then struggling to meet locally with Home Office contractors, with representatives from the hotels where people are staying, and trying to deal with some of the issues that are arising and resolve them locally. The issues that are arising, though, are very much the same across all the different accommodations. And I think that by fragmenting these issues, pushing them down to local level, the Home Office are continuing to get away with providing substandard accommodation and support to people. Before I go on to talk a little bit more about the issues that we're seeing, I want to say a little bit about, well, I want to make a few things clear. So the first thing is, we are very much in favour of people being accommodated in London whenever possible in terms of asylum seekers. We've been saying for years that the dispersal policy causes huge harm to individuals and to communities, because you're sending people to areas where there aren't resources to support them, and often putting them in areas where there's a lot of deprivation and it causes problems. There should be asylum accommodation in London, if at all possible. I also want to stress that some of the accommodation that people have been put in is in many ways an improvement on what's usually provided as initial accommodation, although admittedly that can be quite a low bar. Some families have been put in self-catering student accommodation, and some of the hotels are of a better standard than we've been used to seeing. But what we are seeing is that people are being stuck in this accommodation for very long periods of time, for months. And so the issues around provision are exacerbated with lockdown on top of everything else, and people being stuck in a single room with no facilities and with inadequate provision. I also want to say that the build-up of people in initial asylum accommodation, in Section 98 accommodation, is absolutely nothing to do with COVID. The Home Office has failed for a number of years to meet its own targets in processing asylum applications. Therefore, people aren't leaving asylum accommodation in dispersal areas, and no additional accommodation has been sourced. If anything, the Home Office is lucky that this is happening now, because hotels are at least presently willing to take in asylum seekers because they can't operate as usual. And actually, asylum applications are at the lowest in years, because there's been a huge reduction in numbers of people entering the UK, despite what we see in the papers about people crossing the channel. It is the case that people are not being evicted generally from dispersal accommodation at present, but the numbers involved in who are potentially up for eviction are quite small, so that hasn't really had an impact. I took a look at some statistics earlier, just to try and prepare a little bit for this, and I usually take Home Office statistics with a pinch of salt. But what I was looking at showed that, yes, numbers of people in dispersal accommodation have grown. So the figures I were looking at started in March 2017, when there were about 39,000 asylum seekers in dispersal accommodation. And at the end of December last year, that had grown to 45,000 people in dispersal accommodation. So yeah, that's growth. But the numbers of people in Section 98 accommodation, this short-term accommodation, had increased from about 1,500 in March 2017 to over 12,000 by the end of December 2020. So that's an incredible increase in just a couple of years' time. And as I say, that's nothing to do with COVID. It's really to do with the Home Office failing to deal with immigration applications. I suspect most of their resources are now being redirected to deal with the EU settlement scheme and things like that, but there we are. So what kind of issues are we seeing people dealing with? One of the ones which comes up on a regular basis, one of the most widespread and most difficult to deal with, is the inadequacy of the food that is being provided in the Section 98 accommodation. Initial accommodation is supposed to be full board, so all your meals are provided. Although for some of those in self-catering accommodation, they're given a supermarket voucher at the moment, so that's slightly less of a problem, although it's a very low level of support they're getting. But in the hotels, people can't leave their rooms and eat communally because of lockdown. So they're being provided with meals in their rooms. And the accommodation providers keep telling us and in all the other local areas we've spoken to, that it's just impossible for them to cater for everyone's needs. However, I'd like to at least see them try, because it doesn't feel like they're even trying. We've had reports from health professionals of people developing digestive problems while they're in the hotels because the food is too spicy for them. We've heard about no individual provision being made for meals for children. In one place, they've recently been told that there's no budget for children's food, which is entirely untrue. Pretty much no fresh fruit or vegetables being provided for people. Very small portions, food being served cold, and people not provided with plates or utensils, but being told to eat it out of boxes, and no provision for snacks for children. We heard of one hotel where they were using leftovers from a local takeaway to cater for people. So the food would arrive late at night and stone cold. So the issue of food and provision of food is an ongoing issue. And as I say, you might manage with poor food for a week or two, but this accommodation is going on for months. So people have been expected to survive on this now for months at a time. Another common issue we're seeing is inadequate provision of toiletries. We had one hotel where people were given a toothbrush, a miniature tube of toothpaste, and a miniature bar of soap when they arrived, and refused any other toiletries. We've heard of women not getting sanitary provision, and from mothers who aren't being provided with sufficient nappies or wipes for their babies. We're also hearing about other aspects of inadequate provision in terms of what's being provided. Again, when you've got these people in hotels which are theoretically quite nice hotels, it's easy to get this kind of knee-jerk reaction where you say, how dare people complain when they're being accommodated in beautiful hotels? And I've seen recently some newspaper headlines, front pages, asylum seekers being accommodated in 4-star hotels, as though they're ordering off room service and nipping down to the spa for a massage and a steam in their spare time. It's really not the case. They're essentially being put in rooms in these places, and that's all. And often, as I say, what they're getting isn't sufficient. So no matter how nice the room, if you have a new baby and you're not provided with a place for that baby to sleep, or if you're bottle feeding a baby and there isn't a place where you can prepare a bottle, then that is clearly inadequate. There are stories we've seen of families who are all being put in one room, and often expected to share beds, even with some older children, and people being put in windowless rooms. So general provision is inadequate in itself. More worryingly, and something which again has been highlighted in the press recently, is people being told that they risk being thrown out if they leave the accommodation for too long. There was a case highlighted in the Independent last month of a client who was being evicted because she'd left a hotel for 24 hours. She was told that she was being treated as an absconder, and it took the efforts of various charities and lawyers to get her back in. That's not an uncommon experience. We hear of people who are told that they can't leave the hotel for more than an hour as it's against lockdown rules, or that if they leave for too long, they'll not be allowed back in. Of course, asylum accommodation is provided on the basis that a person has no other accommodation available to them. So an extended absence or frequent overnight absences might lead to this being questioned. But having accommodation withdrawn with no notice and no apparent right of appeal in an arbitrary manner is clearly wrong. But again, reflective of what happens when the Home Office subcontracts its functions to a range of providers who then feel that they are authorised to exercise various powers. People who do complain about what's going on are often being intimidated by hotel staff and told it will affect their asylum application. We've been told about this more than once, told that if they question the accommodation, then they could get into trouble. Asylum seekers are obviously in a very vulnerable position, and bullying such vulnerable people is really objectionable. We do know that people who do complain or who get organisations to help them challenge provision usually do get moved out to better accommodation, and that sometimes can happen quite quickly. But the systemic issues which are underlying the problems remain unresolved. Another issue we hear about quite a lot is people being moved at very short notice without being told where they're going to. So you're supposed to get a certain period of notice when you're in Section 98 accommodation if you're going to be moved out to dispersal accommodation, but this is not happening. People are being moved often with just a few hours notice, and this includes families with children who found school places or registered with GPs. I heard one really distressing story quite recently of someone who was called by an asylum seeker that they had been assisting. And the asylum seeker said that she was being moved. She was in a taxi. She'd been told to get her stuff and get into the taxi, and she was being taken somewhere, but they hadn't told her where she was being taken, and that the taxi driver was refusing to tell her where she was going. I just can't imagine how frightening that must be for anyone, but particularly for someone who comes from a country with oppressive regimes where people are often disappeared and that kind of thing. So I just cannot believe that that is being allowed to happen. So just to finish up really in terms of what we're seeing, we're hearing over and over again from the Home Office and from their contractors that the Home Office intends to move people out of the hotels by the end of March. And again, that often makes it quite difficult to take legal challenges to some of these things because there's a lot of uncertainty about, well, how long is this going to be happening? Is it worth us getting into legal proceedings at this stage? Because, you know, what happens if it's all moved and changed again next week? Few of us actually believe it's feasible for the Home Office to move the number of people who are in London right now out to dispersal accommodation by the end of March. We've seen a change in the language that they're using at the moment in terms of some of the self-catering accommodation seems to be now being redesignated as slightly longer term accommodation. And they've made some noises that some of the families will be kept there. However, again, nothing is really clear at the moment. The Home Office doesn't tell us. It doesn't tell the people in the hotels. And so people struggle to know what to do, whether to bother registering with a GP or put their children in school or to try and challenge things or not, because they just don't know how long they will be there. Just to finish, I think, you know, we don't know how long they'll be there and how long this will go on. I think it will go on for some time longer, but I strongly suspect that the Home Office has absolutely no idea either. Thank you.
Bethan, thank you very much. Thank you for all the excellent work you've been doing, for your excellent talk, your eye-opening talk. I mean, I, for one, was completely taken aback by the kind of lack of any provisions, accommodation, food provisions, and the sheer fear, the absolute fear and insecurity that so many asylum seekers are experiencing. So thank you very much. Just before I introduce Simon, what I didn't mention, so eager was I to get onto our speakers, what I didn't mention was that if you want to ask questions, please put your questions in the chat box. We'll be taking questions at the end for both of our guests. And please direct them, if you can, to Penny Hari or David Renton, who will then pass them on to me. If you want to ask the question in person, again, please indicate that in the chat box. If we have time, as is customary at HLPA meetings, we will have an information exchange at the end of those questions. So, and also I should say, again, it's in the chat box, just to remind everyone that the meeting is being recorded. Okay, that's enough from me. Simon, over to you.
Thank you very much, Marina. Hello, everybody. I've got some slides that I'm going to talk to, if that's okay. Marina, can people see the slides?
Yes, I certainly can. So if I can, I'm sure most people can, yeah.
Really trying to pick up what Bethan described, to take a little bit of a step back to remind ourselves of what the powers are that are being used here, and then to talk through some of the legal arguments that housing practitioners who want to challenge what Bethan's been describing is going on in London, and some related issues that are happening in other parts of the country, to suggest that the legal basis for those and the arguments that people might use. And as Bethan said, we don't know what's going to happen. People may have seen that it seems that the Penally camp in South Wales near Tenby is now going to close. I hear it's going to close with effect from Monday to asylum seekers, and that all the asylum seekers will have been moved out. And I mean, just perhaps a few general observations before we get into this. I think it is important, one important takeaway from what Bethan said is that this is not being caused by COVID. This is a function of the Home Office having taken on 20 years ago to be responsible for the accommodation of asylum seekers, and yet never really having stepped up to that challenge, never really appreciated that what they were doing was carrying out a social services function, a housing provision function, and it isn't simply ancillary to the Home Office's immigration functions. And one of the solicitors I work with told me last month that it seems that the Home Office has never had a policy, for example, for dealing with disabled children in asylum support accommodation. So for 20 years, the Home Office has been taking responsibility for children in families, and yet has never worked out what you do if you have a child in a wheelchair, with the consequence this child had been accommodated for a very long period of time, months or years, in accommodation where the bathroom was upstairs. And I think the second point to take away that is a theme, I think, of how we challenge this systemically, is that what I'll show you is that the Home Office has retreated into a very narrow, thin Home Office function with very thick, expensive contracts either side, one to accommodation providers and the other to migrant help. And then what's left in the middle seems to be, though we don't know, a very small Home Office team that's taking decisions, but that in fact is not really supervising the operation of the providers that it has contracts with, who are in turn not really supervising the subcontractors that they have contracts with, that migrant help is not operating an effective complaint system. And certainly what I've seen in litigation, and other people may have seen this, is that when you send letters before claim to the Home Office will reply, well, that's not our fault. That's the accommodation provider's problem. To which our response is, well, they're just your agents. You're the one with the legal duty. But the Immigration Department has a very long experience of blaming everybody else for its own failures, whether that's migrants or lawyers or judges, or now it's contractors or migrant help. And this makes it very difficult to get the Home Office to take responsibility for what it's doing. I'm going to suggest some strategic pointers. So what I'm going to talk about, first of all, I'm just going to talk briefly about two issues: a new judgment on local authority powers, and secondly, a new High Court symptom mechanism for interim. And then I'm going to get into the meat of what's trying to deal with some of the legal problems that Bethan's been raising. So just to recap on the duties and powers that the Home Office has to destitute asylum seekers. Somebody has unmuted yourself, so if you can mute yourself, wherever you are. Thank you. Two sets of powers. First of all, for asylum seekers, sections 98 and 95 of the Immigration and Asylum Act 99. Section 98, the initial power for someone who appears to be a destitute asylum seeker, and the section 95 power for someone who is a destitute asylum seeker. Now, often this is seen as the division between initial accommodation and dispersal accommodation, but in legal and practical effect, that is not how it works. We have many people who are section 95, the full power, still in initial accommodation. And then alongside that, we have a section 4 power for people who are destitute former or failed asylum seekers and meet certain other conditions. I'm just going to touch on some of the litigation around that. I'm not going to go into detail. And then lastly, to remind people, there is a wider power for anyone on immigration bail, which is the power under Schedule 10 of the Immigration Act 2014. It's sometimes used for asylum seekers, in particular where they are coming out of prison and having served a criminal sentence and are subject to particular restrictions, for example, as a sexual offender. So in a very new development, I thought I'd bring some of the newest stuff from the last fortnight to you. Judgment last week in the case called Nkube against Brighton, in which Brighton said that they had not had the power to accommodate failed asylum seekers under the everyone in policy. And so Mr. Justice Friedman was asked to decide whether or not they did have that power under two different statutory provisions. One is section 138 of the Local Government Act 1972, which is a power on local authorities to act within their area in the situation of an emergency disaster. Brighton tried to argue that the pandemic was not an emergency in Brighton at the time in question because they were still in tier 1. And the judge said that wasn't right. In fact, this deadly pandemic that we're in the middle of, even in Brighton, constitutes an emergency. And that therefore the local authority had power to accommodate people who were excluded from the homeless provisions of the Housing Act as ineligible. And secondly, consider the power under section 2B of the National Health Service Act 2006, which is a target duty to take steps that the local authority considers appropriate to improve public health. And the judge held that that also gave Brighton the power to accommodate people. But what he went on to talk about was, he went on to uphold the case law that the Localism Act operates to continue the exclusion from housing powers, discrete housing powers, of ineligible persons, and to say that really those people fall under, or can be treated as falling under, the Home Office's power in section 4 that I showed you there for destitute failed asylum seekers. So crudely speaking, what we might take from that is that he's holding that local authorities have a power to accommodate everybody, regardless of what anybody else is doing, but they're not going to have a duty in human rights to accommodate failed asylum seekers because those people can turn to the Home Office. Now, this section 4 has also been the subject to a lot of litigation during the pandemic. First of all, the Home Office had a policy from March until about September, which they reverted to in December, that they would not evict people. And that they would not evict them from the section 95 or section 98 accommodation. In other words, if their asylum claims were dismissed and they were appeal rights exhausted, they still wouldn't evict them. They would accommodate them under section 4. It's a parallel to the local authorities, everyone in policies. And then when they dropped that, when they withdrew from that policy in September, a judicial review was brought in a case called QBB, and Mr. Justice Fordham made an interim order in November holding the ring for the people who were already accommodated at that date. But since then, the Home Office have adopted that approach to a much broader class of people, including people who are only falling out of Section 95 after the 2nd of November. So in practice, the Home Office's current policy is that once you're into Section 95 or Section 4 accommodation, you won't be evicted. That's the current policy. Since December, they've been threatening to withdraw it in light of improvements in the pandemic situation. They said that in December, and then the situation obviously tragically didn't improve. And since then, they've been saying that they're going to do it next week. And each week is next week. And we're still waiting. I'm involved in that litigation. So the current policy is that they won't evict anybody from Section 4. As Bethan said, that is really quite a small number in the total figures. Figures Bethan gave us, there's 70,000 people accommodated at the moment under Home Office Section 95 or 98 powers. We're looking at, we don't know the figures. The Home Office doesn't disclose and doesn't appear to keep proper figures. In the judicial review that we brought KMI, which I'm turning to, the Home Office said they had no idea how many failed asylum seekers are in the country, even though the Home Office is the only body that refuses asylum and the only body that removes or escorts failed asylum seekers out of the country. They had no idea how many people were here. So we can only guess, but we think maybe somewhere between 2,000 and 6,000 people are currently being accommodated under the don't evict policy. But in parallel to the don't evict policy, the Home Office has refused to admit people into accommodation. They don't accept that there's still any and everyone in, as far as they are concerned. And they say it's not a breach of everybody's human rights to refuse to accommodate a destitute asylum seeker, even though that person may then spread COVID to other people. The Asylum Support Tribunal judges have all disagreed. Since December, every single appeal has been allowed against the Home Office. And the result of that is that at a hearing earlier this month in the case called KMI, the Divisional Court ordered a simplified and expedited High Court procedure for interim relief. In this class of cases of people who've applied for Section 4, have been refused by the Home Office and are appealing, if their destitution isn't in dispute. And I'd encourage housing practitioners to take a look at that. It's on the Asylum Support Appeal Project's website, where they've got a suggested form. But I think it's a very interesting development much more broadly. It was the Divisional Court's response to our application for a class injunction requiring them to accommodate parents pending their individual appeals. Because we said, look, they're winning every appeal anyway. And the Divisional Court didn't like that. You can read the judgment. And but instead created of their own motion a procedure which has no costs, no fees, no need to file the claim form, and an application form that need only be 2 pages long. And you can see the proposed application form that ASAP have created. It's not approved by the High Court. The High Court didn't approve a form. The contents of the form are in the KMI order. Copies of the order and all of that are available on the ASAP website. But what that means is now that applicants are applying direct to the High Court with the assistance of, without a solicitor, with the assistance only of an NGO. The Home Office has 24 hours to respond to the application. And so far as we know, they've all been granted so far by Mr. Justice Garnham, who is single-handedly taking responsibility for these. I think it's an interesting phenomenon that courts have become less and less accessible, and so it's become more and more bureaucratic. And obviously Parliament has created tribunals that don't have powers to order interim relief, but eventually at a certain point, the court will crack and order a big workaround, which is what's happening here. So I'd encourage people to take a look at it and think of similar solutions in other areas, and it will be interesting to see whether or not it gets entrenched. But it may not last long, because on the 15th of March, this week, the Asylum Support Tribunal specified a lead case. The Home Office has now got off its haunches and has decided to challenge the approach of the tribunal, and is arguing that human rights aren't even engaged by the pandemic. There's nothing to see here. There isn't any, no one's Article 2, 3 or 8 rights being protected by accommodating anybody. We don't have to accommodate asylum seekers. Failed asylum seekers. I should emphasize this is section 4 for failed asylum seekers. And that hearing is now listed for the 8th of April, and the tribunal is now staying similar cases. The tribunal has a power to direct a lead test case and then to stay cases that look similar. But where it's staying, it's telling those appellants about the expedited, simplified interim relief mechanism. And the judicial review challenges themselves are due to be heard in early May. That's a challenge to the refusal policy. There's a challenge to the September policy to start evictions, which has been stayed behind KMI and EW. Who knows how this will change? Who knows whether or not the Home Office will introduce a new policy as they've been advising they might for the last 3 months. So that's the situation with the Section 4 litigation. Turning back then to the context of Bethan's talk. So who's arranging the Home Office accommodation? Well, a couple of years ago, the Home Office entered into 10-year-long contracts, and they're all available. All of the detail of the contract is available on the internet under the Home Office's EU law duty to publish contracts that have been dealt with under public procurement. And if you search for AARC contracts, you'll find them, or AIRE for the migrant help contract. So there's 3 different providers doing 5 different English regions, Scotland, so 5 different English and Welsh regions, plus Scotland and Northern Ireland. And those 3 providers are Serco, Mears and Clearspring. And then there's a single provider, Migrant Help Limited, which deals with the information and complaints handling. Now, I think this is a really interesting area for litigation, and we can see that from an important case that was done that finally got judgment in December called DMA. Now, that was a challenge to delays in the provision of Section 4. It wasn't about the quality of accommodation, but what's really significant about it was the judge's finding that the Home Office weren't supervising the contracts with Serco, Mears and Clearspring. And I think there's reasoning there that I think may well be found on the evidence to hold true for the food issues, for example, that Bethan was talking about, or the quality of accommodation or overcrowding that we'll come on to. But what's also interesting in that judgment is it gets close to, but doesn't quite get to, a finding that the Home Office had unlawfully delegated their statutory duties to the contractors. That wasn't argued, and that wasn't the way the case was put, but I also think that's an interesting point. Because I think what we might see on the evidence is that the Home Office has such a thinly staffed office that it's effectively leaving it up to hotel staff to decide what quality of asylum support is provided and to decide who gets told what about whether they might be threatened with eviction. So, and these contracts are they're really worth looking at. There's a lot of words, but they are worth looking at. So, for example, I've only pulled out some illustrations here. They had very detailed accommodation standards down to the level of cleanliness, the level of repair, lots of features that you'd expect in a very well drafted contract, that you want to make sure that you're providing people with good quality accommodation. And on the food point, for example, the contract requires these providers their menus have been validated by a suitably qualified nutritionist or health professional as being appropriate to dietary needs, and that's true for eat. They're also required to provide specific menus for people who have different cultural or dietary requirements. And the advice contract is similarly very demanding. If you look at the contract that Migrant Help operates under, they're very short time frames for passing on complaints. They don't decide them. Passing on complaints to the accommodation provider, getting an answer, reverting to the asylum seeker with the reply to the complaint, advising the asylum seeker that they can escalate the complaint to the next level, escalating the complaint, reverting, and then ultimately in the 3rd round, escalating to the Home Office. And we know in practice that migrant help don't pick up the phone, don't answer emails, tell asylum seekers not to whinge and complain, tell them they're lucky to be accommodated. But we also know migrant help are doing some good work. I'm not saying that that is the totality of what migrant help do, but we know that there are numerous examples of failings by migrant help. But what you'll find if you claim judicial review is that the Home Office will say, well, you should use migrant help. They'll call it an alternative remedy. And even if it isn't really, we may get the High Court understandably saying, well, what did you do through the complaints mechanism? So one point to practitioners is, if you are advising clients in these situations, then I would encourage people, as soon as the client comes, to encourage that client to complain to migrant help, send an email, keep a copy, keep a diary of their conversations, their attempts to get through on the telephone line. Let's use these systems. Hell, maybe they work, and that's great. And if they don't work, then that gives us the evidence to go to the court and say, not only is your accommodation system being operated unlawfully, but your complaint system is also being operated unlawfully. Now, the Home Office isn't securing, as you've heard from Bethan, the Home Office isn't securing the compliance with those contracts. So we're seeing lots of cases of people complaining about unfit for human habitation accommodation. Some of the most extreme were in Penally Camp, which was operated by Clear Springs, and in Napier, which was operated by accommodation providers, and was presumably asserted by them to meet their contractual standards, and yet clearly wasn't meeting their contractual standards. So I've had clients where they were sleeping 4 people to a 2-bed room, where the statutory housing requirements on overcrowding were clearly being violated, as Bethan's described, poor quality food and complaints being ignored. And as Bethan said, the Home Office is allowing its private contractors to also violate people's rights. So in both Penally and in Napier, but also we think in hotels, people are being subjected to an effective curfew, which under Supreme Court jurisprudence is unlawful detention. So if people are being told that they can't leave the hotel, then subject to the possible defense of COVID arguments, where there's strict compliance with the COVID regulations required, you may have clients who are entitled to bring unlawful detention claims. And it may be that a few unlawful detention claims against hotel managers would really wake them up as to what they're doing to the individuals in their accommodation. Secondly, as Bethan mentions, we're seeing unlawful threats to withdraw accommodation. As Bethan pointed out, this accommodation is provided on the basis that people are destitute. Once you're in it, destitute means that you don't have accommodation that's available to you that is adequate for the at some point within the next 56 days. So the fact that you've got a mate who'll let you stay for the weekend doesn't mean you're not destitute. And what these are is they are petty bureaucrats and petty hotels managers and security staff trying to control other people's lives, in my view, completely unlawfully, without any basis. And we're also seeing NGOs being refused to allow in to hotels to visit them, which would appear to be a violation of the EU Reception Directive and quite possibly contractual provisions that need looking at more closely. So how do we do these legal challenges? Well, first of all, the principal remedy is judicial review. It's to the High Court. It's not to the upper tribunal. As many of you will know, the upper tribunal has a jurisdiction to deal with immigration cases, but challenges under section 98, 95, and 4 are explicitly excluded from that jurisdiction, so it goes to the High Court. There isn't a right of appeal to the Asylum Support Tribunal. It's only against a decision to stop providing support. So it seems to me that that combination of decision and stop means that one can't appeal, even if one's asserting that what has happened is in effect the end of the provision of accommodation because it's no longer adequate. But there is an argument under the Reception Directive, and I'll come back to how that plays out, that an appeal is required. So there may be arguments that, if needs be, the High Court should make factual findings. For example, as they do in unlawful detention cases, as they do in disputed age cases about children, even those are judicial review. But obviously, if you're down to damages only, then it may be right to bring the claim in the county court. So what's the legal basis for some of these arguments? Well, firstly, the accommodation has to be adequate. Obviously, adequate, so how long's a piece of string, but it's a starting point for what we're talking about. There isn't any similar language for what are essential living needs, but the Home Office's policy, which led them to decide how much money asylum seekers get, identifies certain brackets of needs. So that may help an argument. For example, if people in hotels are if women are being denied sanitary products, if mothers are being denied nappies, as Bethan was saying, may provide people with a legal basis for arguing that the Section 96 duty is being breached. But another approach could be to look at the Home Office contractual standards. I mean, these are, in my view, the detailed working out of what the Home Office thinks is the minimum standards for asylum seekers. They form the key performance indicators for the contractors. So it'd be interesting to see what both the Home Office made and what the High Court made of reliance on those standards. That doesn't mean that a small slip up, it doesn't mean that a defective skirting board is necessarily going to prove that the accommodation is unlawfully inadequate, but it may be a useful starting point for the meat of the argument about adequacy. The second legal instrument that might come in useful is the Asylum Support Reception Conditions Regulations 2005. Three particular provisions there. These require the Home Office to try to accommodate. Sorry, it says must. That's an overstatement. Must. I think I've lost the words. Must try to accommodate immediate family together. That where there are children or other vulnerable people, pregnant women, victims of torture, people with mental illness, that the Home Office must take account of their individual needs, or their special needs. That only arises under the regulations where there's been an individual evaluation. The regs, though, however, say that doesn't mean the Home Office has to do it. And in practice, the Home Office hasn't wanted to do this. And in my view, certainly a good argument that a GP's view that someone has certain needs, an educational psychologist's view, an occupational therapist's view, a social worker's view, can count as an individual evaluation. And then lastly, Regulation 5, which is the central provision, which imposes a duty on the Home Office to provide accommodation under sections 95 and 98. And there's a question mark there because I don't know the answer. But there seems to me a legal argument that brings in the rest of the provisions of the Reception Directive, at least so far as they go to the adequacy of accommodation and the extent of the essential living needs. Now, how do we get to rely on the EU Reception Directive anyway? Okay, we've left the EU, implementation period is over. Well, the answer is that the regulations haven't been revoked. And that so long as they haven't been revoked, then under the EU Withdrawal Act, they're required to be interpreted and applied in accordance with the principle of the supremacy of EU law and to give effect to the Reception Directive. That's 2003/9. Some other regulations have been revoked. One footnote, I haven't got the year of the Reception Directive wrong. There is one made in 2013, but the UK did not sign up to that Reception Directive. So we are stuck with the old form. And then lastly, the Asylum Support Regulations 2000. Most of the provisions there probably aren't very relevant to the legal arguments that we're running, but Regulation 20 is particularly useful because it sets limits on what kind of conduct and what kind of behaviour can lead to discontinuation of accommodation. And also sets out that has to be done through an individual evaluation with notification to the individual. And I think Regulation 20 is part of that package of tools that can be used to address overmighty officials. So some particular arguments that you also might invoke for families. So there's a Home Office policy on accommodating extended family members, and obviously one can invoke Article 8 of the European Convention on Human Rights and Article 7 of the European Union Charter of Fundamental Rights as to the interpretation of that binding EU law when looking at how the regulatory scheme should be operated. For children, Article 10 of the Reception Directive requires the state to organise their education. So some of the cases that I've been working on include situations where children really couldn't study at home during the pandemic because of the overcrowded conditions. Is that a breach of the Secretary of State's duty arising under the directive? And of course, the special provision on duty to have regard to best interests of the child under Section 55 that applies to these powers because they're immigration powers. Persons with disability, we've been arguing discrimination, the duty to make reasonable adjustments, and the PSCD. We've also argued the PSCD in relation to children. And then lastly, damages. Three bases there. Article 8, I mean, one can also invoke Article 3. I've represented clients who, a client who was in an urban house in Leeds, which became a hotspot for COVID early on. A poor man who found himself climbing out of the window of his ground floor room to avoid meeting anybody else. So frightened was he, as a rather elderly man with a severe medical condition, of contracting COVID and getting really sick. In these cases, we've been invoking the Equality Act damages provisions in the judicial review, and also EU law, though the right to Frankovich damages is not going to arise unless there are people with particularly brilliant novel arguments for damage or at least for events that occur after the end of the implementation period. I think we will have to wait and see what the courts say about events that occur before that, but that cause damages after that. Now, you might be thinking, what's the point of getting damages? Because won't the client be on asylum support? And asylum support doesn't have any disregard for the purposes of any capital amount. Some clients may, of course, have succeeded and they have asylum or they have some other form of leave to remain. That means that they're now on universal credit, which is more generous for the amount of capital that one can have. But also, we have had some success in negotiating settlements with the Home Office in which four-figure sums have been approved, and it's been agreed by the Home Office that that wouldn't have any effect on their receipt of asylum support. I think in that case, they may have wanted to avoid a ruling on some of the arguments that I've been flagging here. So that is a canter through. Sorry if it's been quite fast, but canter through some of the possible legal arguments that we might bring to bear on the issues that that Bethan talked about in London. And really just to emphasize that I'm afraid everything that I'm hearing from my clients and the solicitors who instruct me does chime with what Bethan is saying. I think we're seeing hotel staff in situations that they hadn't expected to be in, and without any training, again, which is a breach of the Reception Directive, dealing with people with a very wide variety of needs, quite often people who are traumatized, people who have escaped persecution. We've had clients who've escaped armed camps surrounded by barbed wire and who were then put in Penally, which is a camp full of Nissen huts surrounded by barbed wire, and who are being re-traumatized as a result. So Penally is closed, but some of these hotels, while not surrounded by barbed wire, may nevertheless be really quite oppressive. And they're not only in London. I mean, Bethan's field of work is in London, but we're seeing similar complaints from hotels in the north, in dispersal areas. And one point I want to just pick up on this before I finish is that, just clicking back to the case of DMA, what was disclosed in DMA is that, because what we don't have is the financial amounts of these contracts, but what was disclosed in DMA is that the Home Office has negotiated a fixed per person rate for everybody. So the Home Office pays the same rate to Serco for everybody who's accommodated, whether they have special needs, whether they're accommodated in one place or another place. And as the judge pointed out in DMA, that provides a powerful incentive against accommodating people who have special needs because they're going to be much more expensive. But what it also makes inexplicable is why the Home Office opened Penally and Napier, because they have this contract under which they can just click their fingers and tell Serco, sorry, we've got another 300 people here. Go and book a hotel. Put it on your tab, not on ours. So it's the Holiday Inn. Tough luck. You signed the contract. This was the risk you took. So I do think that once it comes to the public inquiry that we need to have, there'll be serious questions about why Priti Patel needed to persuade the MOD to open these terrible camps when she had this amazing contract that could be used over the private sector. I'd be very interested to see the response. We know that in the planning decision that the Home Office announced, because the Home Office had the MOD and the Home Office had the power to switch the use of Penally Camp to something else for 6 months, that the Home Office said that there was no other accommodation available in the country for 250 people in September of last year, in the middle of a pandemic when all the hotels are empty. So there are a lot of very interesting and important questions to ask, and I would encourage everybody, housing practitioners, ultimately there are some immigration aspects to this, but a lot of it is really housing. We would really welcome you rolling up your sleeves and getting stuck into this field, because there are a lot of people out there who need high quality representation. Thank you. Back over to you, Marina.
Simon, thank you so much. A lot to take in, a lot to think about. We will make the slides available and hopefully email them out to all the participants tonight. Thank you, Simon. That was great. I certainly need to think about some of the things you've said. I have a couple of questions, so I will take those questions and then hopefully there'll be a bit of time for some information exchange. The first is to Simon. I'm going to read this out. What does Simon think of the decision in Nkube, and especially the way the judge dealt with the Localism Act? The decision reads as if the claimant had been hoping for a bit more in the Act and finding that the powers under it were subject to the Human Rights Convention. Simon, that's over to you.
Well, I think the Localism Act, so for those of you who aren't familiar, this is really the argument that the provisions in the Localism Act that say that pre-existing restrictions on rights will apply to local authority powers. I think there's an extreme reading of that, which Brighton adopted, which is that the Localism Act applied to the Section 138 powers, for example, which I don't think runs, because I don't think that because there's a difference between a restriction on a power to provide housing and a power to assist people more generally. I do see the logic that if the powers are very similar to those under pre-existing legislation, that the restrictions apply. I think the real challenge for the issue in Nkube is the judge's point that it had become academic. And I think the large problem there is that the Home Office wants to be the agency that's accommodating asylum seekers and failed asylum seekers where accommodation is required under the Human Rights Act. So I think always the problem for running that in Nkube is that the local authority and the judge will say, well, hang on, the Home Office are happy to do this. Why do you need a ruling on the local authority doing this? Of course, the problem has been that the Home Office used that power to say these people aren't entitled to any accommodation because it's not a breach of their human rights. They can go home. They can leave the country. They're failed asylum seekers. And so the Home Office wants this power actually only not to use it. And of course, then these people are sleeping on the streets of the local authority. They're not sleeping on the streets of the Home Office. Home Office doesn't have to deal with them. So we know that in the pandemic in March, that Leeds and Liverpool said to the Home Office, well, we want to accommodate these people because we want to solve this problem. And can you tell us where they are and who they are? And the Home Office said, no, we're not going to tell you because you don't have any power to support them. So that was the Home Office's response. Probably also the Home Office doesn't know where they are. So we are now in the Section 4 litigation in this very strange position, because I'm involved in these cases, really of saying to the court, look, my client doesn't have any claim to stay here. My client isn't going to leave, but the Home Office haven't removed him. And in the interest of everybody's public health, they should accommodate him. But he's Home Office responsibility. If they can't remove him, they should accommodate him. And I think the Home Office find that very painful because they don't really like taking responsibility.
Well, that brings us to the next question, actually, which is, you mentioned the Section 4 litigation and the lead case, which I think is going to be heard on the 8th of April. And I just was going to ask one question about whether you were able to expand on really the Home Office position in respect of that case, which I think you've briefly done already. What is their position? I mean,
we've been litigating this since October. And the Home Office has and in each letter that we send to the Home Office, we now have 7 clients, 4 counsel, 2 solicitors firms. In each letter we send, we say, you're still not complying with your duties of candour. You still haven't told us. What did you take into account for public health purposes? Did you do any quality impact assessment? Where is it? What do you think the public health risk is? So at the hearing on this test case, the Home Office's position was that the individual destitute asylum seeker should be the person who has consulted with Public Health England and who presents his case that him being refused accommodation poses a sufficiently serious public health risk to other people. He should be the one who presents the epidemiological evidence. He should be the one who presents the public health evidence. And the Home Office don't have a duty to do anything. That was their case.
So on a case-by-case basis?
Yeah.
So he as an individual will have to have access to all the material that the Home Office have, but they're not going to give it to him. He has to establish his case on a case-by-case basis. So he personally poses a threat, not the pandemic generally, but he personally poses a threat. Is that essentially it?
Yeah, the Home Office there's been a series of FOI requests to the Home Office. The latest reply was the Home Office have oscillated. Well, the Home Office's current position is that it would cost more than £600 to check everybody's emails to see what information they've received about public health. That's in a department that they did admit there that they have they did claim anyway, that they have a Public Health England person embedded in the department. I dread to think what that actually means, but that this person, and that most of the advice they provided has been verbal. But what the impression we get, and I can't say with any confidence because they just won't give us any information, the impression we get is that they have studiously avoided asking, is it a public health risk to evict people or not to accommodate people? And all they said is, assuming we're going to evict people, how should we go about that to mitigate the public health risks?
But if it wasn't a risk, how does one then explain the stay on evictions, which has been extended, I think now 3 times? It just seems a bit of an odd approach, surely. Well, there was a stay on possession proceedings, then there was a stay on evictions, and now an extended stay on evictions.
Oh, indeed. Some exceptions. Our case is that, the Priti Patel's the only one around the cabinet table who doesn't think that everybody should be in. But actually, it's better than that, because Priti Patel does think that everybody should be in. Because as I explained, they're not evicting anybody from Section 95 or Section 4 accommodation, even though they say they can leave. So at the hearing that we had on Friday, the judge asked the Home Office, well, are you saying you have a power outside the strict regulations, outside the ECHR provision in the regulations, but under Section 4, are you saying you have a power to accommodate people? Because if they do, well, that power's at large in the tribunal, and then the tribunal can just do justice. It doesn't need to show a breach of human rights. And the Home Office counsel, who was there for the hearing, didn't say yes or no. And when pressed to explain the legal basis of the power under which they're accommodating somewhere between 2,000 and 6,000 people, said it was the spirit of Mr. Justice Fordham's order. And the judge and I both suggested that the spirit of an order isn't a legal basis for a statutory power.
Spirit that everyone can see, the spirit that everyone can see and refer to. Yeah.
That's what we're at now. Yeah. But they are due to file their evidence next week, and but there may be another policy to start kicking people out again. I mean, the policy in September was to kick out, I think, 175 people a week. So anyway, but I mean, it is interesting that Mr. Justice Fordham, it is a lesson to us lawyers of what you can get if you ask. And Mr. Fordham made an interim class order on the papers, which has effectively accommodating up to 6,000 people for what's coming up now for 6 months.
Yeah. I've just got two more questions. I know the time. So one from Rachel Lovell. In terms of the contracts between the providers and the Home Office, presumably these cannot be relied on directly by the asylum seekers to enforce any particular aspects that are not complied with, as they are not party to those contracts, but can be used to evidence the standards that should be expected in the exercise of Section 95, Section 98 duty, and to show that duty is not being met?
Yes. And I would add Section 4 as well. The contracts cover Section 4 accommodation too. Now, we don't have a statutory duty in the same way about Section 4, but we could easily get into, once you've decided to provide Section 4 accommodation, it must be adequate. And that's C contract for what is adequate. But yes, I think you're right.
Okay. Thank you, Simon. And one question for Bethan. If people wanted to get involved with the work that Praxis do, how should they go about it?
It really depends on what kind of work they want to do. We're always open to offers of people representing our clients if they have housing issues, and we do an awful lot of work with people making challenges, particularly around social services accommodation, and we're always very happy to hear from people who are interested in helping us with those. Usually we do it through housing and immigration group networks in terms of taking on people to represent. If people want to help more generally, we do have volunteers who can help, and we have a bit on our website where people can offer to volunteer. So it really depends how people want to get involved.
Okay, all right. Thank you, Bethan. I think those, I'm just double checking to make sure that I've covered everything. Yes, I have. I'm just also just going to check the screen to make sure no one's got their hand up. No, that's it. Well, thank you very much to both our speakers, to Simon and to Bethan. A lot to take in, a lot to think about, but for really showing us the reality of what it's like for so many asylum seekers.